Welcome back, guys. In today's episode, we are going to step into the shoes of the defendant, alternatively the defendant's attorneys, by discussing what to do upon receipt of a summons. If you're served with a summons, it means that another person or entity has instituted legal action against you for certain relief. Before we start, please remember to subscribe and share this channel with your friends. Every bit of support is appreciated. Being served with the summons. Before we look at the options available to a defendant after being served with the summons, we need to briefly touch on the actual service itself. Take note that a summons must be served on a defendant by the sheriff of the court, having jurisdiction. There are a few exceptions to this, such as substituted service. Despite the name, the sheriff is not associated with the police, but is rather an officer of the court. There are many sheriff officers within each province of South Africa, each serving specific jurisdictions. Examples include Randburg West and Sandton South. It is important that we discuss the concept of service, as valid service can be effected in a number of ways. What I mean is that service may still be valid even though you have not personally received the summons. In this regard, please take note that a summons may be served as follows: personally, on the defendant directly, on another person at the defendant's residential or employment address in the defendant's absence, by affixing to the defendant's residence or domicilium citandi et executandi, see my episode on contractual clauses in this regard, by affixing to the defendant's principal place of business and or registered address in the event that the defendant is a juristic person, and on an employee of the defendant where the defendant is a juristic person. There are, however, a few instances where personal service is strictly required, such as where the relief sought in the summons is a decree of divorce. From the aforesaid, it is clear that a summons may be validly served on you or your clients in a number of ways. Therefore, if you find a summons affixed to your gate, for example, do not ignore it. I will explain why you must never ignore a summons shortly. I have been served with a summons. What must I do? First things first, you need to peruse the summons and the attached particulars of claim, if it's a combined summons. Take note of who the plaintiff is as well as the relief they are seeking against you. When considering the summons itself, you will see a paragraph or two affording you 10 days to deliver a notice of intention to defend and a further 20 days to deliver a plea, exception, or notice to strike out. The paragraph will look similar to the following. Inform the defendant further that if he disputes the claim and wishes to defend the action, he shall, within 10 days of the service upon him of the summons, file with the registrar of this court at, and then you'll insert the address of the court, notice of his intention to defend, and serve a copy thereof on the plaintiff's attorney, which notice shall give an address, not being a post office box or poste restante, referred to in Rule 19, subsection 3, if the High Court, for the service upon the defendant of all notices and documents in the action. Thereafter, and within 20 days after serving and filing notice of intention to defend as aforesaid, file with the registrar and serve upon the plaintiff a plea, exception, notice to strike out with or without a counterclaim. So, what then are your options? Although not always financially possible, at the very least, arrange a consult with an attorney as soon as you can. I do not recommend litigating without legal representation, as it is extremely difficult. Depending on your financial status, you may also qualify for assistance from legal aid or a law clinic. Notwithstanding the aforementioned, if you or your client has been served with a summons, the following options are available: do nothing, deliver a notice of intention to defend, attempt to settle with the plaintiff, or admit liability, undertake to pay the amount claimed, and or consent to judgment. I will now discuss each of the aforesaid options. Do nothing. It is certainly not advisable to ignore a summons and simply do nothing, unless the defendant intends on immediately satisfying the relief sought. If a defendant does not deliver a notice of intention to defend, a plaintiff may obtain judgment by default without further notice to the defendant. If the relief granted is monetary in nature, the plaintiff will be entitled to recover the judgment debt plus interest in a number of ways. The most common method of recovery is to execute a warrant against the movable property of the defendant. This means that the sheriff will attach, remove, and sell the defendant's, now also referred to as the judgment debtor or execution debtor, movable property at auction, with the sale proceeds to be paid to the plaintiff. The plaintiff, now referred to as a judgment creditor or execution creditor, may also instruct the sheriff to attach any funds deposited in the execution debtor's bank account, where the account details are known to the execution creditor. In the High Court, the execution creditor will simply issue a warrant in this regard, but in the Magistrates Court, a Section 72 application must first be launched. That's not where it ends. Should the execution creditor be unsuccessful in attaching movables and/or funds, or should the proceeds from a sale and execution be insufficient to satisfy the judgment debt, an application to declare the execution debtor's immovable property executable may be launched. This means that any immovable property registered in the defendant's name may be attached and sold in execution. Take note, however, that the application to declare immovable property executable is extensive, and many rights are afforded to the execution debtor in this regard. Over and above what has been mentioned herein, the execution creditor may also launch sequestration or liquidation proceedings due to the execution debtor failing to pay the judgment debt. Just to top it all off, the execution debtor will also be liable for the execution creditor's legal costs on a certain scale, and may find itself being blacklisted with the various credit bureaus. Therefore, in light of the above, it is pretty obvious why a summons should not be ignored. Deliver a notice of intention to defend. Personally speaking, I'm not advising you, 99% of the time, I will, on behalf of my client, deliver a notice of intention to defend in response to a summons. I will still do so even if my client, the defendant, intends on settling the matter. I say this because legal action is only suspended upon agreement between the parties. If no agreement is in place, the plaintiff may obtain default judgment whilst you are trying to settle the matter. If you or your client wishes to settle with the plaintiff, it is imperative that same occurs before judgment is granted against your client. Delivering a notice of intention to defend essentially buys the defendant some time, as the next move belongs to the defendant. In other words, within 20 court days of delivering the notice of intention to defend, the defendant may deliver a plea, with or without a counterclaim, exception, or notice to strike out. Although I despise delay tactics, this is common and can be beneficial to the defendant. Also take note that if you intend on attempting settlement with the plaintiff, ask whether the DS can be suspended while settlement discussions are underway. This will relieve some pressure if agreed to by the plaintiff. On the other hand, a defendant may of course genuinely wish to oppose the legal proceedings instituted against them. In this regard, a notice of intention to defend will be delivered, and thereafter a plea or notice to strike out, etc., which will set out the defendant's response to the averments in the summons. We will be discussing the plea in a later episode. Now that the basics have been discussed, let's have a look at how to draft a notice of intention to defend. As always, before we do so, we need to consider the relevant court rules. The notice of intention to defend is regulated by Rule 19 of the Uniform Rules of Court, which is High Court matters, and Rule 13 of the Magistrates Court Rules, which is Magistrates and Regional Court matters. The aforesaid rules, which are almost identical, contain the following important provisions. Subject to the provisions of Section 27 of the Act, this is uniform rules only, the defendant in every civil action shall be allowed 10 days after service of summons on him within which to deliver a notice of intention to defend, either personally or through his attorney, provided that the days between 16 December and 15 January, both inclusive, shall not be counted in the time allowed within which to deliver a notice of intention to defend. In an action against the minister, deputy minister, administrator, officer, or servant of the state, in his official capacity, the state or the administration of a province, the time allowed for delivery of a notice of intention to defend shall not be less than 20 days after service of the summons, unless the court has specifically authorized a shorter period. When a defendant delivers a notice of intention to defend, the defendant shall therein give defendant's full residential or business address, postal address, and where available, fax-and-mail address and electronic mail address, and shall also appoint an address not being a post office box or poste restante within 15 kilometers of the office of the registrar, for the service on the defendant thereat of all documents in the action, and service thereof at the address so given shall be valid and effectual, except where by any order or practice of the court personal service is required. The defendant may indicate in the notice of intention to defend whether the defendant is prepared to accept service of all subsequent documents and notices in the suit through any manner other than the physical address or postal address, and, if so, shall state such preferred manner of service. Notwithstanding the provisions of sub-rules 1 and 2, a notice of intention to defend may be delivered even after expiration of the period specified in the summons or the period specified in Subrule 2, before default judgment has been granted, provided that the plaintiff shall be entitled to costs if the notice of intention to defend was delivered after the plaintiff had lodged the application for judgment by default. Taking these rules into consideration, let's draft a notice of intention to defend. Firstly, you will insert the heading, which must feature the case number and identities of the plaintiff and the defendant. The heading will look exactly like the summons heading. In the tramlines below the heading, you will insert Notice of Intention to Defend. Below the tramlines, we will state, kindly take notice that the defendant hereby gives notice of its, his, or her intention to defend the above action, and hereby appoints the address of its attorneys hereunder as its attorneys of record, at which address it will accept service of all processes, notices, and documents in this action. As per the rules, a defendant may indicate on the notice of intention to defend that it consents to service in another manner. This means that a defendant may consent to service via email. Service in this manner is preferable to me personally, but may not be for others. Therefore, only include the following paragraph in your notice if you would prefer to exchange further pleadings and notices via email. Kindly take further notice that the defendant is prepared to accept and prefers the following manner of service of all subsequent documents, pleadings, and notices in this action by electronic mail to lawyerzA@gmail.com. You will then, as be the case with all notices and pleadings, date the notice and insert a provision for signature by the defendant, alternatively its attorneys. Below the signature line, the defendant's or its attorney's full details must be set out. The details to be included are prescribed by the rules, which specifically state full residential or business address, postal address, and where available, fax and mail address and electronic mail address, and shall also appoint an address, not being a post office box or poste restante, within 15 kilometers of the office of the registrar. Ideally, as a defendant, you want to appoint attorneys with offices situated within 15 kilometers of the court. If the firm is not situated within 15 kilometers of the relevant court, corresponding attorneys will need to be appointed, which your attorneys will do. The only issue with this is that your legal fees may be slightly higher than usual, as you will essentially be utilizing the services of two law firms. Finally, the notice of intention to defend needs to be addressed to both the clerk or registrar, depending on which court you're in, as well as the plaintiff's attorneys or the plaintiff itself, if unrepresented. This will look as follows. 2. The clerk or registrar of the above honorable court, and then you'll insert the court's name. And 2, you'll insert the plaintiff's name or the attorney's name, and then the plaintiff's attorney's details and their reference number. Once drafted, we need to sign the notice of intention to defend. Thereafter, it must be served and then filed at court. The notice of intention to defend will look similar to the following. A template of the notice of intention to defend will also be included in the episode notes once released. As already mentioned herein, once you have delivered the notice of intention to defend, you will have 20 days to deliver either a plea, with or without a counterclaim, exception, or notice to strike out. If you fail to deliver any of the aforementioned within 20 days from date of delivery of the notice of intention to defend, the plaintiff may deliver a notice of bar. If you fail to comply with the notice of bar, you will be ipso facto barred from delivering a plea or an exception, etc. The plaintiff may then proceed with default judgment, but more on this in a later episode. If you intend on settling with the plaintiff, get those negotiations going ASAP. You may want to still deliver a plea, however, to buy more time and to protect your client's interests. Attempt to settle with the plaintiff. We've already touched on settlement quite a bit in this episode, but I want to explain the process in greater detail. As you now know, settlement attempts may be made at any time during the legal process, and may be made regardless of whether the defendant is formally defending the action. Settlement negotiations commence when the defendant submits a settlement proposal to the plaintiff. Remember, the timeframes during which legal processes are to be exchanged are only suspended upon agreement between the parties. To understand settlement proposals a bit better, let's look at the following scenario. The defendant breached a contract, and as a result is indebted to the plaintiff in the amount of 100,000 Rand. The plaintiff decides to proceed with legal action and issues a summons in which 100,000 Rand plus interest and costs are sought from the defendant. The defendant decides that he has no defense, or he simply does not want the dispute to drag on, so he proposes settlement to the plaintiff. The defendant may still elect to formally defend the matter. The defendant proposes that he pays 80,000 Rand to the plaintiff in 4 equal monthly installments in full and final settlement of the matter. The defendant requests that the DS be suspended while settlement negotiations are underway. The aforesaid proposal will be enclosed in either an email or a formal letter, which must be addressed to the opposition on a without prejudice basis. What do I mean when I say without prejudice? The term without prejudice means without the loss of rights, and such correspondence is generally inadmissible in court. The purpose of this is to guard against an argument by one party that a concession made or offered in bona fide without prejudice negotiations constitutes a waiver of a right or an admission of liability by the other party. All correspondence pertaining to settlement negotiations must bear the words without prejudice. Now that we know what without prejudice means, let's draft the relevant email or letter in which we set out the defendant's settlement proposal. The exact phrasing may of course differ between people. Dear Sir, Madam, without prejudice, we refer to the above matter and confirm that we act on behalf of, and then you'll insert the defendant's name and in brackets, our client. Our client has instructed that we propose the following: payments in the amount of 80,000 Rand in full and final settlement of this matter, and payment is to be made in 4 equal monthly installments of 20,000 Rand, with the first payment being made by no later than 1 December 2022, and thereafter on the first day of each subsequent month until the full amount has been settled. We kindly request that you take instructions and revert with your client's response at your earliest convenience. In the interim, kindly advise whether your client is agreeable to the DS being suspended while settlement negotiations are underway. We look forward to hearing from you. Kind regards, J.J. Jones, partner, email address, telephone number. Upon receipt of the proposal, the plaintiff could do any of the following: ignore the proposal, accept the proposal, reject the proposal, or reject the proposal and submit a counter-proposal. Admit liability, undertake to pay the amount claimed, and/or consent to judgment. Admitting liability, undertaking to pay the amount claimed, and/or consenting to judgment is specifically provided for in the Magistrates Courts Act, which is the MCA. So this segment will only be discussed insofar as proceedings instituted in the Magistrates Court are concerned. Admission of liability and undertaking to pay debt in installments or otherwise is regulated by Section 57 of the Magistrates Court Act, and consent to judgment and an order for payment of judgment debt in installments is regulated by Section 58. Section 57 of the MCA provides that if any person in this section called the defendant has received a letter of demand or has been served with a summons demanding payment of any debt, the defendant may, in writing, admit liability to the plaintiff for the amount of the debt and costs claimed in the letter of demand or summons or any other amount, offer to pay the amount of the debt and costs for which he admits liability in installments or otherwise, undertake on payment of any installment in terms of his offer to pay the collection fees for which the plaintiff is liable in respect of the recovery of such installment, and agree that in the event of his failure to carry out the terms of his offer, the plaintiff shall, without further notice to the defendant, be entitled to apply for judgment for the amount of the outstanding balance of the debt for which he admits liability, with costs, and for an order of court for payment of the judgment debt and costs in installments or otherwise in accordance with his offer. And if the plaintiff or his attorney accepts the said offer, he shall advise the defendant of such acceptance in writing by registered letter. If, after having been advised by the plaintiff or his attorney in writing that his offer has been accepted, the defendant fails to carry out the terms of his offer, the clerk of the court shall, upon the written request of the plaintiff or his attorney, accompanied by, if no summons has been issued, a copy of the letter of demand, the defendant's written acknowledgement of debt and offer and a copy of the plaintiff's or his attorney's written acceptance of the offer, an affidavit or affirmation by the plaintiff or a certificate by his attorney stating in which respects the defendant has failed to carry out the terms of his offer, and if the defendant has made any payment since the date of the letter of demand or summons, showing how the balance claimed is arrived at. Enter judgment in favor of the plaintiff for the amount or the outstanding balance of the amount of the debt for which the defendant has admitted liability, with costs, and order the defendant to pay the judgment debt and costs in specified installments or otherwise in accordance with his offer, and such order shall be deemed to be an order of the court mentioned in section 65A1. When the judgment referred to in subsection 2 has been entered and an order made, and if the judgment debtor was not present or represented when the judgment was entered by the clerk of the court and the order made, the judgment creditor or his or her attorney shall forthwith advise the judgment debtor by registered letter of the terms of the judgment and order. Any judgment entered in favor of the plaintiff under subsection 2 shall have the effect of a judgment by default. Section 58 provides that if any person, in this section called the defendant, upon receipt of a letter of demand or service upon him of a summons demanding payment of any debt, consents in writing to judgment in favor of the creditor, in this section called the plaintiff, for the amount of the debt and the cost claimed in the letter of demand or summons, or for any other amount, the clerk of the court shall, on the written request of the plaintiff or his attorney accompanied by, if no summons has been issued, a copy of the letter of demand, and the defendant's written consent to judgment, enter judgment in favor of the plaintiff for the amount of the debt and the cost for which the defendant has consented to judgment, and, if it appears from the defendant's written consent to judgment that he has also consented to an order of court for payment in specified installments, or otherwise of the amount of the debt and costs in respect of which he has consented to judgment, order the defendant to pay the judgment debt and costs in specified installments, or otherwise in accordance with this consent. And such order shall be deemed to be an order of the court mentioned in section 65a subsection 1. The provisions of section 57 subsection 3 and 4 shall apply in respect to the judgment and court order referred to in subsection 1 of this section. We all know that legislation can be confusing, so let's quickly dissect these sections to make them understandable. We will start with section 57 and then deal with section 58 thereafter. So, what is section 57 actually saying? Let's have a look. Upon receipt of a letter of demand or summons, the defendant may admit liability to the plaintiff in the amount and cost claimed therein, or some other amount, or offer to pay the amount and cost claimed in installments or otherwise, as well as any collection fees on such installments. The defendant may also agree that in the event of its failure to carry out the terms of the offer, the plaintiff shall be entitled, without further notice, to apply for judgment for the amount in respect of which it admits liability, or the balance thereof if any payments have been made already, together with costs. If the order is accepted by the plaintiff, the defendant must be notified of the acceptance via a registered letter. Once the registered letter has been sent, an agreement comes into existence between the parties in accordance with the rules governing contracts concluded by post. If the defendant does not comply with its offer, which was accepted by the plaintiff may in writing request that the court enter judgment in its favor for the admitted amount, alternatively the outstanding balance of the admitted amount, plus costs. The court may also order that the defendant pay the judgment debt and costs in installments or otherwise, in accordance with its offer. If the defendant was not present or represented when judgment was granted by the court, the plaintiff or its attorney must, within 10 days of becoming aware of the order being granted, notify the defendant of same by registered letter. The judgment or order under this section has the same effect as a default judgment. Simple enough, I'm sure. Now, what does section 58 essentially state? Upon a summons claiming payment of a debt being served on the defendant, or upon receipt of a letter of demand, the defendant may consent in writing to judgment in favor of the plaintiff for the amount of the debt and costs claimed in the summons or demand. The defendant may also consent to judgment in some other amount. If this is the case, the plaintiff may submit a written request to the court to enter judgment in favor of the plaintiff for the amount of the debt and costs for which the defendant has consented to judgment. The request must be accompanied by a copy of the letter of demand, if no summons has been issued, as well as written proof of the defendant's consent to judgment. Where the defendant specifies in his written consent that it will pay the debt and costs to which it has consented in installments, the court may make an order to that effect, which order will be equivalent to an order under section 65a subsection 1 of the Act, the provisions of which will also apply in this regard. If judgment as aforesaid has been entered and an order made, without the defendant being present or represented, the plaintiff must advise the defendant by registered letter of the terms of the judgment and order. This type of judgment or order will have the same effect as a default judgment. Before we conclude, I need to explain the procedure for consenting to judgment. The defendant may consent to judgment by signing the form of consent endorsed on the summons, or by lodging with the court the summons together with the signed form of consent. The defendant may also sign a similar form of consent to that endorsed on the summons, but in such an instance, 2 witnesses must also sign. The clerk will then have a discretion to decide whether the defendant has validly consented to judgment. The defendant may also consent to judgment after delivering a notice of intention to defend. The defendant may even, in its plea, consent to judgment for a portion of the amount claimed. The defendant does not need to notify the plaintiff that consent is given. The clerk will be notified, who in turn will notify the plaintiff. And that concludes our episode. As a reminder, the options available to a defendant after being served with the summons are as follows: do nothing, deliver a notice of intention to defend, attempt to settle with the plaintiff, or admit liability, undertake to pay the amount claimed, and/or consent to judgment. Until next time, cheers.